Well, thank you for attending this webinar. I'm Tom Perrone, and I'm your host today. And it's my privilege to introduce Joe Fournier Esq, an attorney who is a member of the Business and Personal Benefits Planning Group and his own firm in East Haven, Connecticut. And today, It's All in Numbers was going to present to you estate planning overview by Joe Fournier. Joe, welcome to the show.
Thanks. Good morning, Tom.
Good morning to you. So today we're going to go through a number of things, and this should last about 12 to 15 minutes, but we're going to cover a lot of territory. And those of you who would like to send in a question, you can send it to tpnecgginc at comcast.net. That's tpnecgginc at comcast.net. You'll see that email on the bottom left-hand screen. And if you have a question, send it to me, and we're going to get to as many as we can. But Joe, welcome. We appreciate it, and we're going to let you start your presentation now.
Okay, great. This is just going to be a very basic estate planning overview. We'll touch on some of the higher level topics, and certainly if we have questions or if we have more opportunities to do presentations, we can get into any of these topics in more detail at another time. And as Tom said, you can certainly email any questions to us. My name is Joseph Fournier. As Tom mentioned, I am with Fournier Legal Services. We are an estate planning and business law firm serving clients in Connecticut, Mass, and Rhode Island. And our main office is in East Haven, Connecticut. We also have an office in downtown Boston. I also have a CPA license in Massachusetts. I'm not a practicing CPA in Connecticut. When we talk about your estate, there are a lot of times questions as to, people say, well, I don't have a big estate. I don't know if I need estate planning. And the reality is your estate is everything that you own. And what happens often, almost every time I'm speaking with a client or a potential client, is that when you start adding up everything you own, you will find that you own a lot more than you think. That's because you may not have $2 million lying around in your pocket, which is the Connecticut state tax exemption number. But when you add in your home, your retirement plan, your life insurance, your investments, and your other assets, sometimes you are pushing closer to that number than you think. And many people write over that number. Why do we even care about estate planning? Well, estate planning has many benefits. You want to protect the people that you love and that you care about the most. You want to protect yourself in case you have some type of physical or psychological or mental incapacitation later in your life. You want to be in control, of course, over who will receive your assets when you're no longer here. And most people like to minimize legal fees and taxes in an attempt to make sure that their assets go to the people they care about and not to the state or to the court system. And the best time to plan is now. You plan it while you can and before you actually need to do so. And the biggest benefit of planning now, and this is something I remind people often when they speak with us and meet with us, is that you can change things. You're not necessarily locking anything in. And if things change, circumstances change, or if your priorities change later in your life, or the people in your life change, you can always go in and modify your estate plan. We think estate planning is important for anyone. It is particularly important and necessary if you have minor children or grandchildren, if you own a business. As mentioned before, if your all-in net worth exceeds $2 million. If you own property in more than one state, it is essential to take a good look at your estate plan. If financial privacy is a concern for you. If you or your spouse is not comfortable with financial matters, or if you have an estate plan and it's outdated, if you have not revisited that in a long time, it certainly makes sense to do some estate planning.
Joe, I just got an email from Sean from West Hartford, and this is, I'll bring up the topic because he does ask, is estate planning just for the rich or the wealthy?
I mean, I certainly do not think so. I think anyone who has assets or beneficiaries, people in their life, loved ones in their life, or even important causes that they care about, it's important to do some basic estate planning. Proper planning now will cost you a lot less than it will in the future. And even if you don't have a significant amount of assets that you would deem yourself wealthy, there's still lots of planning and things that you can do now to relieve stress and trauma after you're no longer here in an attempt to benefit your family.
I see that on the screen here. We're going to cover it, but Harvey from Woodbridge writes in, what is a healthcare directive and when would I use it? And I see you're going to you're going to talk about that now.
Sure. We're just about to get into that. It's great. Good timing, Harvey. Good segue. When we talk about a basic estate planning, at least in our office, we talk about 3 basic documents: will, living will, and durable power of attorney. Your will is the cornerstone of your estate plan. It directs how your assets will be distributed. It names an executor, which is the person who will be in charge of managing your estate. And you can accomplish other estate planning goals if you'd like to with your will, or it can be very simple. We can get into that in more detail. There's also part of the basic documents. We also do some healthcare planning, which would include a living will, typically a do not resuscitate order, and a HIPAA authorization, and including in the living will a type of advanced medical directive, which basically states in advance what you would like to happen if for some reason you are unable to make decisions for yourself. So clearly finding someone that you trust and finding someone that you can rely on to make rational decisions during what will be an emotional time is an important part of this process. The other component of the basic documents that we typically include would be a durable power of attorney, which is someone who can act on your behalf in the non-healthcare matters, financial, banking, real estate, things of that nature. Those 3 documents are simple, they're cost-effective, and really form the cornerstone, in my opinion, of any basic estate planning.
Joe, I might add that on the durable, power of attorney, obviously, there's a lot of people here who are the children of older parents, and who the older parents do not have an executed durable power of attorney. I would kind of think that you encourage the children to get their parents to get this done sooner than later, obviously.
Absolutely.
Okay.
Absolutely. Makes a lot of sense to take care of it now. And again, you can always modify it later. Lots of estate planning strategies out there. We're not going to even try to cover them all in a 12 to 15 minute webinar. However, I will touch on some of the three biggest items that we see most often and that come up and that we talk about and implement most often. The first one is doing nothing. We do not think that's a good idea. It's called intestacy. The other 2 that we typically work with are wills and trusts. Trusts can be revocable or irrevocable. We can get into that in a minute. We don't think, obviously, doing nothing is a very good idea. Again, this is called intestacy if you have no will. And depending upon which state you live in, you will have laws that govern intestacy. In Connecticut, if you were to pass on without a will, the first $100,000 in your estate goes to your spouse, and then the remainder is split equally between your spouse and your children.
Joe, Roberta from West Haven has an email that says, so what happens if I don't have a will and I die, but with minimum assets?
They would.
I think she's saying, if I died without a will, I own a car and I have a bank account. What's the situation there? What would be the consequences of not having a will?
Typically, those assets would go to your spouse. If not to your spouse, then to your children.
Okay. And if she wasn't married, let's say she was single and died without a will, and let's say just had minimum assets,
Yeah.
particularly driven by either the title on the property.
Correct. How it's owned. Right. You lose control of the process unless you own it titled with someone else. You will completely lose control over your assets at that point.
Good. Okay.
We typically call that chaos.
Yes. Yes.
And the important point is that intestacy, the laws of intestacy, almost never mirror what you would choose to do. I've never seen a situation where the laws of intestacy mirrored what my client would choose to do. Therefore, it's very important to have something even basic in place. Your will is the basic cornerstone document, as we mentioned. It names an executor, also called a personal representative, depending on the state, to manage your estate, and you may name a guardian for your minor children. It only takes effect upon your death. That's the important distinction to make with a will. The document does not have any legal effect until you die. That allows you, obviously, a lot of control and the ability to modify at later time. You will have less control with the will than you will with a trust, which we'll talk about in a minute, and it does not avoid probate.
So I get an email now that says, so this is from Tom from Hamden. What's the difference between a will and a living trust?
Great question. Another good segue. As mentioned, the biggest difference is what I started to mention, as the will takes effect only upon your death, whereas a living trust is a legal document that actually takes effect upon its creation. And it allows you to exert a significantly more control with the trust than you do with the will. And the biggest difference with regard to the control is that the will goes through probate and the trust does not. So you do not have to worry about the overview or the purview of the probate court to manage the distribution of your assets. With a trust, you simply name a trustee, and that trustee will be in charge of managing the assets and distributing in accordance with your wishes. A trust really is nothing more than a contract. It's a legal entity that can hold property. You can fund a trust now, or you can fund a trust via your will upon your death. You name a trustee who will manage the property, and then the beneficiaries are the people who will have the rights in the property itself.
Joe, Joan from North Haven writes in, if you have a living trust, and minor children, can you stipulate different ages of distribution within the trust?
Excellent. Absolutely. There are many ways to do that. We would typically stipulate the distributions in thirds so that a minor child would receive a certain amount of benefits or a certain amount of the assets at, say, age 18, and then another set, maybe another third at age 24, and then another third at age 30. You can pick any ages you'd like. The key point, obviously, is that you don't want someone at a young age to receive a windfall. And the other benefit of that is that the trustee is still in charge, right? So the trustee is still managing the distribution of those assets for the benefit and looking out, has a legal obligation to manage the assets for the benefit of those children.
Her second part of that question was, what if, how do we remove the trustee if the beneficiaries don't get along with the trustee?
So typically you will, the most common manner in which to remove a trustee would be only if all beneficiaries agree. Now the person creating the trust, who is called the grantor, may control that process now to some extent by stating the terms upon which a trustee can be removed. So some people don't trust their children, for example, to get along. So they make it more difficult to remove a trustee. They put the trustee there for a reason. Other clients of mine will let the beneficiaries control that process, and if they agree, they can remove the trustee fairly easily. It really kind of runs the gamut as to what you're trying to accomplish.
Okay, fine.
Some of the other benefits and features of a trust, especially a revocable trust, it does avoid probate. So you're not tied up in the court system, paying the fees, paying the legal fees, and dealing with accountings to the court and things of that nature. With the trust, it's managed by the trustee on its own. It certainly prevents court control of assets at incapacity, for example. If you have a mental or physical incapacity later in life and you're not legally able to take care of yourself, the trust can kick in and control that process for you. To the earlier question, Tom, you protect assets until your beneficiaries are old enough to actually responsibly inherit the property. You may reduce your estate taxes. We do some creative planning with so-called credit shelter trust to minimize estate taxes at the state law level or at the federal level if necessary. We use trusts for business succession planning. And as mentioned, if we use revocable trusts, they're modifiable and changeable at any time, as long as you have capacity to make legal decisions.
Right.
Trusts can also be irrevocable. Lots of planning. We're not going to get into all the detail here, but there are lots of planning techniques with the use of irrevocable trusts. And most frequently, the two that jump out are tax planning and creditor protection. So you can use irrevocable trusts to create liquidity for the estate, to minimize the tax burden. Life insurance planning is an essential part of this process. Creditor protection generally, because creditors cannot get to assets in an irrevocable trust. And for Medicaid planning, if your goal is to protect your home and other assets for your children, then we can use irrevocable trust as part of the Medicaid planning process.
Joe, I know your firm, is doing a lot in real creative planning to have a Medicaid estate recovery trust, which at some point, if any of the viewers are interested in knowing more about, either email me or Joe, because it's a great way of setting up your estate so that there will be an inheritance versus a questionable inheritance because of the Medicaid laws. And okay, Joe, sorry, I didn't mean to interrupt.
No, that's a great point. And it's a complicated topic, right? And every situation is unique. So it certainly is good fodder for another conversation or another webinar or a side conversation. So basically, we do think that estate planning is necessary. The level and the intricacy and the sophistication of an individual's estate plan just depends on the individual's facts and circumstances. Financial circumstances, family circumstances, age, and those are all things we can talk about on an individual basis. But just generally, we recommend the following steps as part of the process. Even if you're not ready to effect your estate plan right now, it really makes sense to write down your objectives. Who are your beneficiaries? Who are the people that you care about? Who would your fiduciaries be? Meaning, who do you trust to manage your estate for the benefit of your loved ones? Make an inventory assessment. Assess what you own. Think about not just how much money you have in your pocket or in the bank, but also what are your life insurance policies? What do your retirement plans look like? What do you think the true value of your home is? And then get serious about moving forward with the process. Think about a professional that you think you can trust and learn from, and have an initial meeting to talk about these things. Often you'll get a free consultation. You certainly will with my office. We're happy to give some education and some background on these topics. And then moving forward, we would typically recommend preparation of the basic documents at least, and often a trust. And whether or not you need revocable or irrevocable is something we would talk about at the time. After the documents are prepared, you could then fund the trust either immediately or in the future or over time. And certainly as your family situation or financial situation changes, periodic updating, periodically reassessing your estate plan is an important part of this process.
Joe, having been in practice in the estate planning world for 47 years, I can tell you, even if people have these documents for a while, they should get a second opinion, because the laws are always changing in the estate, income, and Medicaid law. And I think if you haven't really reviewed your certain situation as to whether your documents are doing what you want, especially with any accumulation of assets, you might want to review. And I know in the past you've always been very nice about having free consultations with our clients and friends, and I believe you'll make that same offer for any of the viewers today.
Yeah, absolutely. Absolutely.
Because Donna from Brantford did ask, how much does it cost to see you for an hour? And I guess you're answering that. Come on in for a free consultation. You'd be happy, right?
Correct.
So, okay, we're getting to the end of our period of time. Joe, anything else here that we can cover, or we?
No, I think we're good.
We're good.
Excellent.
Well, Joe, would you give out your email? You'll have to announce it on the recording here. I don't have it on the screen.
Sure. Yeah, I'll give you my email and phone number. My email is jfournier@jeflegal.com. That's jfournier, Fournier, at jeflegal.com.
And I'm sorry. No,
I'll throw in our office phone numbers, 860-670-3535.
and if you didn't get that, you can email me and I would forward it to Joe. But Joe, I want to thank you. I know getting this into a period of time is very difficult, but we're going to be doing a couple of other webinars on specific stuff in the future. But I do suggest to you, for those of you who are listening to us, if you haven't had a review, give Joe a call. He's a great guy to work with, and his firm and his staff is very competent. And so, Joe, thanks for taking the time.
Thanks, Tom. It's great.
All right. Well, everyone, thank you for joining us in this webinar this morning. Thank you.